Good afternoon. It's just gone 2 o'clock. I'm Anli Hatting. It's a case of David and Goliath as the Please Call Me inventor and Vodacom clash once again. Story of the week starts here.
From bureaus across the country and around the world, this is ENCA Now.
The row over how much money Vodacom owes the Please Call Me inventor continues. The telecoms giant made billions from Nkosana Makate's idea. His supporters descended on the company's headquarters on Thursday, calling for him to be paid tens of billions of rand. ENCA's John Bailey takes a look.
Between 7 billion and 70 billion rand. That's how much some analysts are saying Vodacom owes Nkosana Makate. The company is reportedly offering him 49 million rand as a settlement for his Please Call Me idea. That's even though Vodacom's admitted to the Constitutional Court it's still raking in billions via the service. Makate and the company reportedly reached a verbal agreement that he'd receive 15% of the revenue generated from his invention. But Makate is saying to date he's received no money and hasn't agreed to any deal. One thing that's angered many is that Vodacom's former CEO, Alan Craig, lied in his autobiography, claiming the free message service was his idea. Something the Constitutional Court found no difficulty in rejecting. In 2016, the court ordered Vodacom to enter into negotiations with Makate to determine a reasonable settlement. Despite extensive talks lasting nearly a year and a half, the two parties couldn't come to terms. The court then ruled it was up to Vodacom's CEO to make a determination. But the rumoured 49 million rand on offer has been rejected.
The determination of the CEO, from my perspective, was considerably generous. And I think he was brave and had courage to make a determination.
Makate is now taking the matter back to court. Civil society and some politicians continue to show him strong support. John Bailey, Johannesburg.
In 2016, ENCA's Nkosana spoke to Nkosana Makate shortly after the Constitutional Court ruled in his favour. Let's take a look back at what he had to say when we visited his family.
Nkosana Makate, also known as the Please Call Me guy, relaxing with his wife and daughters. He says the support he's received at home is what kept him going through his fight against cellular giant Vodacom.
If you believe in your case, you believe fervently in your case. Stay with it, push it, and never give up. You know, you'll get negative vibes. You'll despair at some point.
His camera-shy wife, Dr. Rebecca Makate, was the inspiration behind the widely popular free messaging concept.
The concept, I mean, it came about with my battles with my then girlfriend, who's now my wife, because I didn't understand whether she doesn't call me because she doesn't have airtime, or whether she doesn't call me because she doesn't want to call me. So I had to make sure that I guarantee calls or initiation of calls coming from her, and that's how the penny dropped.
Makate's mother is also relieved the long court battle has finally ended and her son will receive the compensation he deserves for his idea.
She was quite excited. She actually told my brother, younger brother who was in court, to actually kiss me, and my brother refused to do that.
His daughter is still unsure what the fuss is about. She's just happy to see Dad on TV. What did you see on TV yesterday?
My dad.
And how did you feel?
Fine, happy.
Happy? Are you happy for him? What was he talking about?
I have no idea.
The judge has given Vodacom 1 month to negotiate a compensation deal with Makate. Makate says the news hasn't fully sunk in yet, and for now all he wants to focus on is relaxing with his family without the stress of the case hanging over their heads. Nkosana Makate, Pretoria.
Legal disputes involving big companies like Vodacom have brought intellectual property into the spotlight. What can we learn from the Please Call Me saga between the mobile giant and Nkosana Makate? To discuss that, I'm joined in studio by intellectual property law expert Ryan Tucker. Thanks for your time.
Thank you for having me.
Right.
It's a real pleasure.
Let's start off with the key issue here. There was no written agreement between the two parties in this particular dispute. Is that correct?
That's correct. So there was a verbal agreement, which is obviously much more difficult to prove in court.
Absolutely.
Yeah.
And have there been significant disputes as to the details of that verbal agreement in the ongoing case?
As far as I understand, yes. Obviously, if there are no written down terms, who's to say his version or the company's version is the correct one?
Yeah.
We need to rely on conduct, we need to rely on extraneous factors to determine what exactly are the essential terms of that agreement.
Okay. And obviously in a case like this, what has a lot of South Africans riled up is it's a case of big money versus the little guy. So, Vodacom has considerable legal representation, while Mr. Makate presumably wouldn't have as much access in terms of financial assistance. How does that influence a dispute of this nature?
I think that, first of all, we must understand that, as far as I'm aware, he is backed by litigation funders. So he does have some litigation support. But having said that, generally in this type of situation, a Goliath versus David situation, David is in a very precarious position because he's come up with something, he's created something that either falls within the Copyright Act, the Patent Act, the Designs Act, whatever it might be. He's created something that's unique. He's created something that's really valuable. It's a huge asset to any company.
And then in this case has been a huge money spinner.
Exactly. And then he's left in the situation where he has no representation, he has no ability to actually fight for his cause, and eventually he actually just peters out because, let's be frank, the Goliaths of this world can throw paper at you until the cows come home, and you're just going to have to withdraw your application or your summons because you won't have the funds to continue.
So often in cases where intellectual property is questioned, the law states you have to go back to the employment contract. Is that correct? And that often employment contracts do cover intellectual property so that the employer has rights to any ideas or concepts or developments made by individuals employed by that company. Is that correct?
That's correct. Generally, there's a clause in assignment, intellectual property assignment clause, which basically stipulates that all intellectual property that is created during the currency of that employment contract will be assigned to the employer. And that's where the sticky situation comes in. What actually are the obligations of that employee? Was he creating that work or that invention during the course and scope of his employment? There's a case, the King versus the South African Weather Service case, which stipulates that, even though it may not have been during working hours, or it may not necessarily have been at his workplace, it was in the furtherance of his employment. He was doing something, he was creating a software program in the furtherance of his employment, and therefore it's owned by the employer. Yeah. In this situation, he was an accountant. Okay. A very different situation. Yeah. I think that there's room to maneuver there based on that.
But I also think I want to explore, not to be the devil's advocate, but just to have a balanced view. The view of, in this case, Vodacom.
Yeah.
It's very easy to automatically take the side of the underdog because that's what we're geared to do. We want to see little people winning.
Yes.
However, in this case, we can't negate or overlook the fact that Vodacom must have invested significant capital into the development and implementation of this idea in order for it to work.
Correct.
So surely that would mean that it wouldn't be fair to be asked to fork over their entire earnings out of this idea. So who decides the balance? Who decides what's a fair settlement?
Ultimately, that's left to the courts to determine. Sometimes in this situation, the Constitutional Court have told the parties to go back and decide for themselves, to actually come to some sort of agreement where there's some mediation process that's taken place or should take place in order to come to a reasonable settlement. But generally, it's the court. It's left to the courts to decide. That reasonable man is ultimately that judge.
The court. So in this case, there's a huge jump from the 50 million or 49 million sort of loosely agreed upon, and the 7 to 70 billion, which in itself is quite a huge stretch, that Makate's supporters are now calling for.
Yes. Having said that, I mean, as you said, they've put in significant effort, labour and skill themselves in developing this idea beyond the initial spark that perhaps the applicant in this case came with, Makate. Yeah. So perhaps we could look at this as a co-authorship or co-inventorship situation where the initial spark came from him, but it was further developed by Vodacom's employees as well, to the extent that it was packaged and came in a different sort of manner, or it became something new in its own right. And I think that there might be value in that as well. We also mustn't forget that it was an agreement that was reached. He didn't protect his invention by filing a patent application up at the beginning, right at the outset. And that was maybe to his disadvantage. Had he filed...
Can I jump in there and just ask, how accessible is filing a patent to an ordinary person? Because I understand it's a time-consuming and expensive process. So is that really an option to the ordinary guy who's come up with a brilliant idea, knows it's going to work, but doesn't have the kind of funding to go through all those necessary steps to protect himself? Or has it become accessible?
I think in South Africa it's exceptionally accessible, in my opinion. The cost versus comparing with the United States or with Europe or with Australia or any of those countries, it's exceptionally accessible. At the moment, there's no substantive examination of patent applications here in South Africa. So there's no necessity for there to be a patent examiner who's examining substantively the merits of your invention and whether it's new and inventive and industrially applicable, which are the requirements of a patent. So in effect, I think that it's very accessible here. I think it's even more so accessible for Mr. Makate, he was an accountant who presumably earned a salary which could have facilitated his filing a patent application.
Is it possible, lastly, just to talk about the legal loopholes, if my employment contract states that anything I come up with during the time or course of my employment belongs to the company, is it then possible for me to even go aside and file a patent and say, well, I'm going to try this legal route to try and protect myself? How do you go about it?
I think that filing that patent application would certainly have put him in a much better position, a much more, a far better bargaining position with Vodacom, because he would have had something substantial to actually say, listen, I filed this patent application. It may not have gone through to registration yet, but this is something that I can negotiate with. This is something that I have on paper. The intricacies, it's hugely nuanced, as you can imagine. Patent law and intellectual property law is hugely nuanced. And now with this border or this transporting into the contractual realm as well adds an additional flavour to it because of exactly what you said, that there's generally an assignment clause in these agreements.
But essentially the lesson to any South African who might have or have the potential to have those kind of ideas is that you have to protect yourself from the onset. You cannot expect an employer to go out of their way to protect you, because essentially it comes down to the almighty dollar.
Unfortunately so. I think that as much as we all want the underdog to win, we have to understand that it's a commercial enterprise. We understand that intellectual property as it stands is a vehicle for making money. and it's a way to actually go about doing that. So I think that it's very important at the outset for every single individual who has a really good idea, whether it fall within the Patents Act, the Designs Act, or copyright, trademarks, whatever it might be, to protect themselves first, to file the necessary applications, and to take the steps that are necessary in order to protect themselves. Even in this case, I think that Makate was a little bit short-sighted in actually just concluding that verbal agreement. I think he should have gone a step further and actually gotten a written agreement in place which would have stipulated exactly what his rights are and what the obligations of Vodacom are. And that would have certainly led to the taking it out of the murkiness. There would have been less murkiness to this whole issue.
Absolutely, and none of us ordinary people are legal experts, and that's what people like you were there for, to assist people in putting together the right kind of agreements to safeguard their ideas and their income.
Yes, and I think that that's a lesson to be learned here in this case, is that whenever you come up with something, you should always speak to an attorney first. We are specialist attorneys. Intellectual property attorneys are specialists in their field, and I think that it's vital that out there people realize that they cannot just go on a handshake. They should definitely visit an attorney, seek out that advice, that vital advice that they need, because I have seen so many times this David and Goliath scenario, and it's such a difficult position to be in, to advise someone like that, because their rights, they may have the strongest rights, and despite that, they're fighting against the Goliath.
Right. Thank you very much for your time. That was intellectual property law expert Ryan Tucker speaking to us about the Goliath and David battle going on between Vodacom and the Please Call Me inventor.